And you guys are live.
Good morning, everybody, and welcome to another edition of MSATP TV. Joining me this morning is Peter Haukebo from the law firm of Frost Law, and he's going to tell us a little bit about himself, and then we have some questions for him, and primarily we'll be talking about the PPP loans. So if you have any questions, please enter them in the chat session so that we can make sure we get those questions asked and answered for you. Peter, take it away.
Well, first, just want to say thanks to Bill and MSATP to having me here today. As Bill said, I'm an attorney at Frost Law. What I do is tax controversy work, and so what that means is anytime there's a dispute between a taxpayer and the government, that's where we step in. So everything from audits to cases in district court or tax court, that's where we specialize, and that's where we get involved.
Okay. The first question that we have for you, if you're a first-time applier for the PPP loan, do you have to comply with the new rules, or do you follow the old rules for last year's PPP loans?
Right. So good question, because by now everybody should know that on December 27th they re-upped. They did a PPP 2.0, and so one of the conditions there was that in order to get PPP 2.0 you had to have had PPP 1.0, and the 2.0 had a harm test, I guess is what I would say, or a financial reduction test. So 2.0 said you had to have a reduction in gross receipts of 25% or more. That was not involved in the 1.0. So to answer the question directly, no, you don't have to comply with the new stuff. The rules that were in place from the March 27th, initial CARES Act, and the 2020 to 27 interim final rules that came out address what 1.0 is required. IFRs came out after the December 27th legislation addressing the 25% reduction and some of the additional rules. But no, they are separate. There are different rules that apply to each.
Okay. Where do you go to apply for the PPP? Does it have to be your own bank, or can you pick any bank that you want and apply for them for the loan there?
Right. So this has evolved over the last year. Gosh, I can't believe it's a year. Initially, one of the big complaints about the PPP was, these banks were prioritizing their best customers, their biggest customers, and that's when you got situations where, the Lakers got the PPP loan, and Ruth's Chris, got the PPP loan, and that kind of stuff. And initially these banks were saying, well, we're going to prioritize our folks, before anybody else. That has loosened up. Certainly, I think if you have an existing banking relationship, it makes sense to work with them. But throughout this process, I think it was even before the Flexibility Act was passed in June, you had these fintech firms, Cabbage, QuickBooks, and Intuit got into it, that are available as well. So you can use an online resource. The community banks and credit unions have been getting into it. There's private lenders that are signed up. Keep in mind that the PPP program is built on top of the existing 7A program from the Small Business Administration. So, as long as that lender has a relationship with the SBA, they're going to be able to go and get the loan for you.
Okay. Could you go over some of the rules for the new SBA, the 2.0, for the PPP loan?
Right. So, the big thing that they added was the 25% reduction in gross receipts, and that's a quarter over quarter analysis. So, and you just have to have that reduction for one quarter. So if your Q1 of 2020, is 25% less than your Q1 of 2019, that makes you eligible. And it just needs to be one quarter. The government used their brain this time and they said, or you can, have a 25% reduction annually if you don't have a total breakdown, and that'd be fine too. So they're just looking for a reduction of 25% or more. The other requirements, so, the IFR that came out, I think it was January 3rd, basically said, the other conditions are going to be similar. They're not changing any of the other rules in the way that it works for folks. The other stuff, they did reduce, the maximum loan amount is now 2 million instead of 10 million. The maximum number of employees is now, I think, 300 employees less. For PPP 1.0, it's 500 employees. There are some very important affiliation rules and things along those lines that, you get deep in the weeds on it. But for the most part, they're the same. The big thing, though, is that 25% reduction that, you're going to have to show them that you had that reduction at some point before you apply for forgiveness. So they actually made it somewhat easier. One of the big complaints or things that I think about from PPP 1.0 was they passed that bill on March 27th, and they built in a safe harbor related to forgiveness that basically tracked 30 days to get the funding and get everybody back hired and to work. And so what that told me is Congress thought that they were going to have all this, the funds in folks' hands within 30 days, and this was going to be a quick process. They have tried in 2.0 to make that funding a little bit faster, because what we experienced from 1.0 was nobody got their money within 30 days, and it was a mess. And so they've said that you don't necessarily have to prove that 25% reduction on the front end, and they can rely on certifications that you had that 25% reduction. But what they're doing then on the back end is saying, well, you got to prove it before you apply for forgiveness. But the big difference is that there is actually a harm test, right? You have to show that you had gross receipts reduced by 25% or more. One important thing to think about is, what does that mean? What is 25% reduction in gross receipts? So basically what they've said is, it's according to your already established accounting principles. So if you're an accrual-based taxpayer, your 25% analysis is accrual-based. If you're a cash-basis taxpayer, your 25% reduction is cash basis analysis. So that's the one important thing. Otherwise it's according to general accounting principles. There's not a goofy formula or anything like that they're messing with you. They're just saying how you've been doing it is fine. There's interesting rules. If you acquired a business or you acquired a new line, you had something else going on, give me a call and we can work through some of that stuff. But there's some details there that if you've got interesting fact patterns, it's worth taking a deeper dive.
Okay. And the application that they're using this time, is that much different than the last time?
No, it's similar. They put out these model forms, which is helpful. It tracks to the language of the CARES Act and to the Flexibility Act and those types of things that include the certifications. The banks and the fintech firms and all that kind of stuff, they're not required to use this form. They have created their own things, these portals that folks are going in and checking boxes and providing the information and uploading the forms. They all track back to that model form that SBA is putting out, but it's not required to be used. I think the language in the IFRs are saying something like, substantially similar, something along those lines.
Okay. And during the first PPP loans, you had to have a relationship with a bank, it seemed like, in order to get the loan. But that you were saying is not the case in PPP 2.0?
It's not, but it's probably still, best practice to use somebody that you know. I mean, so if you have a relationship already, it makes sense to me to continue working with them. Not required. I mean, like I said, initially it was just the banks that had existing relationships under this 7A program. So, the idea, the PPP idea is not new. And it was built on existing legislation. So all of these, the CARES Act, the Flexibility Act, the Recovery Act in December. I mean, all this stuff it's temporary changes in law. The interim final rules that have come out, there have been about 30 of them, I think, at this point, which is exhausting to go through and to read. Those are all temporary changes to SBA and Treasury regulations. So no, you don't necessarily have to have a relationship. At first, the reality was that, the brick and mortar traditional banks were the ones who had these relationships with the Small Business Administration. But, as soon as these other firms realized that they could make money off of this, they went and established a relationship. And so, I mean, these banks, they get their cut up front, and so they get paid up front, and then, you turn around and the reality is they want you to get your forgiveness right away so that they can get your loan off the books and they don't have to service the debt. I mean, because they've already gotten their payment and it's not worth it for 1%, interest to keep this going much longer. So they're going to be very interested in you, applying for forgiveness. And that's one of the terms that, a lot of these banks are adding into the promissory note is that, you're going to do the things that you're required to do, or that this legislation contemplates. What are those things? I mean, it's making sure that you pay 75% toward payroll costs, not more than 25% toward non-payroll costs, that, you're eligible for full forgiveness. Certainly they've been lobbying, the government and the new 3508S form that has come out that says, you can make a self-certification that, you did all the right things. And, if your loan amount was under 150,000, your forgiveness is going to be very, very easy. It shouldn't require anything more than that. So that's they're trying to make this as easy for everybody. And so if there's one thing to think about, and I think this program was captioned specifically about forgiveness, right? They are trying to make this as easy as possible for folks, especially at those lower dollar amounts, under 150,000, to get the forgiveness.
Okay. Now, do you have to have your PPP 1 forgiven before you're eligible to apply for the PPP 2?
Great question. The answer is no, but there is an important distinction here. So you have to have used all of the PPP 1 funds before you can go back and get the PPP 2 funds. And so, one of the things that we've been seeing at the firm, and frankly, that was unclear in the early January interim final rules, was, what happened if somebody didn't apply for PPP 1? Could they go back quickly, get that PPP 1, spend it, and then by the deadline for PPP 2, go and get that second draw? And what we've seen is the answer is yes. Banks are processing PPP 1 applications. It's a challenge for some businesses to then use all those PPP 1 funds and then get back in to the PPP 2 by March 31st. So there's definitely been proposals and lobbying out there to say, let's extend. I think AICPA was saying they were trying to extend the deadline for another 60 days, I think is what I saw, for those PPP 2 loans. So So yeah, I mean, you have to use the PPP one before you can go back for the PPP two, but that's the only requirement. You don't
Okay,
have to have forgiveness. And frankly, I think everybody, just as a best practice, should sort of slow down on the forgiveness stuff, right? Like we learned, I mean, the big thing last year was, well, fine, the income isn't income, but are the expenses going to be deductible? I mean, we found out through the December 27th legislation that yes, they are deductible. So, you know, great result. I mean, for taxpayers, as far as that goes, I'm just telling people to slow down on the forgiveness. I mean, I understand wanting to get it off your books, but at every step since March 27th, you know, the original CARES Act, they've made it easier and easier and easier for especially for the lower dollar stuff. Now, if you're
right,
multi-million-dollar loans and you want to get those off the book, completely understand that's fine. But if you're, you know, under that 150,000, just take a breath. And you know, eventually they're going to come out and the banks are going to use the 3508S form, and they're going to turn it into a template, and they're going to make it super easy for you to apply for forgiveness. You know, so that's what we're seeing. I mean, I think the forgiveness gets a lot easier as we go along.
okay. Now, as far as the PPP one, and I'm sure you answered this before, but I didn't catch it, and I want to ask it again. Are the rules for PPP one today the same as they were a year ago? Or do you still have to have the 25% reduction in order to be able to get a PPP one loan now?
They are the same as a year ago, informed by the 27 or so IFRs and 50 something FAQs that have come out. But no, there is no harm test. Now, the only thing to think about with PPP 1.0 is that you do still have that certification that was given everybody agita, you know, during this, that said that this loan is necessary to continue business operations. I don't have the exact language with me, but
right.
you know, so you still have to think about that. But you know, people were asking us left and right about what this, and I was sitting on phone calls with boards, you know, getting folks comfortable that they could sign these certifications. And you know, you had legislators coming out and trying to retroactively read in this harm test that just frankly wasn't there. And there's other harm tests that were part of that were part of the CARES Act that, you know, Congress could have added in if they wanted to, and they didn't. And so, you know, what I was saying is, look, I think you need to be able to articulate how these funds are necessary to support ongoing operations. But, you know, and they sort of came back later and said there's this idea of access to liquidity and things along those lines. None of that is part of the CARES Act. And, you know, it you know, they added some regulations. I mean, that's really the only thing to be thinking about as far as 1.0 goes. 2.0 just sort of adds that harm test and says you have to have a 25% reduction in gross receipts. Okay.
Well, I appreciate your time this morning. Is there anything else that you feel like we should know about the PPP 2.0 or anything else?
Sure, just briefly. And this came out, I think it was March 3rd. So you know, if you remember way back when, March 27th of 2020, they came out and they said, you know, first employee-based businesses are going to get, you know, the first draws on this. And then after that, it's going to be the self-employed folks. I think it was like a week or 10 days later that they opened that up. And, you know, our firm actually filed a class action suit related to some discriminatory, you know, results with that. And generally speaking, the self-employed person was like the worst situated person out there because, you know, the government basically said, even though you're borrowing based on 2.5 times or 8 weeks of your net business income, you know, you're only going to get forgiven for effectively, 2 months of that. And so by definition, the self-employed person wasn't going to be in the same position as, somebody with an S corp, right? And then progressively throughout these things, it has gotten better and better and better. And now the self-employed person is on the same footing, and actually even, owner employees of some of these S and C corps and partnerships are actually getting crammed down even worse than a self-employed person. So the tables have completely turned. And then on March 3rd, they came out with a new interim final rule and basically said self-employed people can borrow not just on line 31 net business income, they can actually borrow based on gross receipts, less a couple of things related to employee benefits and the like, but then you add back in your employee stuff. The bottom line that, I just want to make sure people are aware of is if you are self-employed, if you have self-employed folks who haven't done the application yet, it makes a ton of sense for you to sit down with them and work through this new IFR that came out on March 3rd, because they have a choice. They can either choose to borrow based on that line 31 net business income, or they can do the line 7 gross income less a couple of things. There's a computation to be done, but strategically, and you guys will be adding a ton of value to them if you sit down and work through that, because now they're in a great situation to borrow even more and to still have it forgiven. So definitely, it's not retroactive. It was very clear in the harshest of ways that if you've already gone and done 2.0, you can't go back and change it. But after that March 3rd came out, if you haven't done that computation yet, it definitely makes a lot of sense to sit down and work through it.
Okay. All right. Anything else?
No, I as always, stay tuned. I mean, this stuff is ever changing. There's been, as I said, at least 30 interim final rules that are tweaking everybody, what everybody's working on here. There's been 50 or 60 FAQs out of Treasury. I mean, that's the big thing is there should be no rush for forgiveness, right? You have 10 months after the end of your covered period, which is 24 weeks. So, I mean, there's just a ton of time on this. And unless there's a really compelling reason to rush to, the finish line, I would just sit back and take my time and see how this all plays out, because it's only getting easier.
Okay. Well, Peter, thank you very much for joining us this morning. We do appreciate you giving us your time. And if there's anything that we can do to pass some clients along your way, I hope all of our members will look to Frost Law for conflict resolution issues and pass it your way.
Absolutely. I appreciate the time, and I'm happy to take calls. If you or your clients or have some unique situations, give me a call. We'll talk it through and figure it out for you.
Okay, sounds great. Thank you very much, and have a good day.
All right. Bye-bye.
Bye.